So too, recent successes. And, you know, one of the reasons we're successful, you got a few little rituals that you do.
You mean I have some quirks? Are we
You
going
can
to
call
start
it
off
that.
with my quirks?
Yeah, yeah, yeah.
Okay, so whenever I'm doing a trial, I have the same pen that I use since 1993, a Waterman pen, which I always use for trial, and it's in a pen case. And it's the exact same pen since I started practice, and I have had a few panics over the years.
I've seen you
Yeah,
panic. Yeah.
because I'll leave my pen in certain places, and I'm like, oh, where's my pen? And so I got to have my pen. Back when I got called to the bar, I had a leather binder made.
I want one just like it. It's a
They're hard
great
to come
binder.
by now, but I had a leather binder made, which is where I put in, my notes and my cross-examination and stuff. So I used the exact same binder. It's always for the same trial.
This is fascinating.
Yeah, sure it is. And oddly enough, I wear what would be my favorite watch to every trial.
You recently tested that theory. But
Yeah,
aside from that one time, you always wear the
I
same
always
watch.
wear I always wear the
Which
a,
is
a
what?
Rolex Submariner, which I was lucky enough to get a long, long time ago, and so I just don't do that. But on one day when I was getting judgment, I tested that with a Omega Planet Ocean, and we still got an acquittal. So maybe my
Omega.
superstition doesn't completely hold out. And no matter what the length of the trial is, I wear the same underwear. So if
I
it's
didn't
2
need
days
to
or
know
14
that.
days,
I didn't need to know that.
just kidding. So, all seriousness aside,
This was a very this so what
We
we're
had a
talking about
really-
a recent success on a very serious case because it was an historical allegation.
look, it's vindication for the client. God bless.
Yeah.
This guy had suffered over the last 2.5 years, depression, anxiety, lost a lot of weight, was really, really suffering. The family was suffering. And he had dated this young lady. I think we spoke about this briefly, but he dated this young lady almost 20 years ago for a very short period of time, from about the beginning of June to the end of middle of early July, way back in 2003, and wasn't a successful relationship. And then 19 and a half years later, charged with a sexual assault. And he's like,
Where'd it come from? But you said vindication, and so I want to
I
focus on
feel
that
there was
because
vindication in
we-
it, but
we-
you and I will
well, there
debate
was,
really
but
what came
I
out
want to
of
make
it.
the point that it is very rare, and people need to understand this. Majority of the time, you go to trial on sexual assault allegations, the judge is going to say that they aren't sure beyond a reasonable doubt. That's not vindication. This was one of the few cases where they actually said they found him to be factually innocent. Didn't use those words.
Yeah, so we've had findings where the judge has made factual findings of innocence. We've had that, and it's rare, and we've gotten it a few times. You and I will debate this a little bit, but I think this was a pretty close finding to innocence.
We debate a lot of things.
We do, but I think it's important. But why don't you just frame the allegation so everybody understands? So we're doing, this is sort of a case study, but there's some important elements here, and I have to say, some real braveness from the judge, who happened to rule from the bench after we filed our written submissions and made oral
We'll
submissions.
explain what that means.
But ruled from the bench and made a couple of very brave statements that I think are in line with current case law, but still brave. So why don't you set up the scenario so everybody understands what we were dealing with as a case?
Well, first of all, I want to say that, especially with historical allegations, people primarily will come to us and say, well, there's no evidence, there's no proof. And, this was a case where, although our client was acquitted in a very dramatic way, I would say, that the judge made it clear when she testified in chief, meaning when she gave her initial evidence before being cross-examined, that she was entirely believable. She was emotional. She looked traumatized. Her evidence was compelling. And he used that word. It was very compelling.
Well, you certainly got the impression that she had suffered a real trauma and was communicating portions of the allegations in a very emotional, believable way.
Yeah. So that's what happens when you first go to trial. The prosecutor is going to call, whether you're in the States or, same prosecutor, because we call it Crown in Canada, but the prosecutor is going to call the chief, usually at the start, will call their chief witness, which is the complainant, and they get to testify unimpeded about what they allege happened to them. And this is a very difficult time for people when they're accused, because they have to just sit there in silence and listen to the evidence being presented. And that person may cry and may come across, as in this case, extremely credible.
Yeah, no, she was definitely compelling. And so this was an allegation that the complainant had said that she barely knew the accused, that she had known him through a group of friends. They had friends in common. They had seen each other at parties where there was other people around, that he had asked her out on a couple of occasions, but she turned him down because she wasn't interested in dating him and she'd just come out of a relationship. But primarily she wasn't really interested in him. And then on Sunday in July, there was a party that she had, and he attends
For her birthday.
Yeah, I don't want to say too much because I don't want to identify anybody, but I want to be careful. But, you know, a birthday party, and our client shows up with somebody else. And at some point, she's lying on a couch sleeping because she's had a lot to drink. And next thing she knows, she wakes up in our client's car, partially aware that she sees a gear shift and that she's in a car. Then she wakes up later in a room which is unfamiliar to her, and she sees or has an impression of our client on top of her, raping her, as she said. And she's in and out of consciousness.
And she used that word too.
Raping. And she wakes up then in the morning. He's still sleeping. She goes to leave. She leaves without her shoes and her purse. She's just trying to get out of the residence.
Because she had no shoes or purse, according to her.
According to her, correct. And she sees people in the kitchen, which she assumes is our client's parents.
Essentially, she said she was kidnapped in the middle of her own birthday party.
Right. So anyway, she sees the parents, and then she exits, goes on a street. She's not familiar where she is. She roams around for some period of time, finds a payphone, makes a collect call, gets picked up allegedly by our client's friend, who then she tells what happened to, goes back to her house, tells everybody who would listen, does not go to the police, does not go to seek any assistance from doctors. She says she's covered in bruises, and sees our client about a week later at a local bar, confronts him in front of a group of people and says, that's the guy who f***ing raped me, and has a discussion with him. And
he gets thrown out of the bar.
But she says, I said to him, just because I turned you down, you had to f***ing screw me. How dare you do that? And he goes, what was I supposed to do? Okay.
Yeah, this is what he's in public. In public, he's supposed to have responded to a public allegation of
on
rape
a patio
by saying, "Well, what else was I supposed to do?"
So then that's it.
Brazen.
And then 19 and a half years later, she decides to go to the police and gives a statement, and our client is charged. Mm-hmm. And for the trial, the complainant is being called to testify.
To be clear, this is what she testified to in chief before cross-examination. And the judge said, despite how bizarre that sounded, that she was absolutely credible and believable in her testimony before cross-examination.
Right. But let's just frame the Crown's case. The Crown's case consists of the complainant. There was no evidence from any of the friends that she allegedly spoke to and disclosed this to. There was no evidence from a bouncer, allegedly, who was at the bar. There was no evidence of any injuries because there's no photographs taken. There was just a complete dearth of other evidence. Now, just so everybody understands, again, in sexual assault cases, there does not need to be corroborating evidence for a court to convict. You simply need the evidence of the complainant to be believed beyond a reasonable doubt. So you don't need corroboration. However, cases stand and fall on the evidence that's called and the evidence that's not called. So an absence of evidence is still relevant.
And in this case, the judge, prior to cross-examination, found her to be very, very credible because she was crying and she looked like a traumatized person.
Correct. But I want everybody to understand that this complainant had said very clearly, I had told everybody who would listen to me. Okay? So there are lots of people allegedly that she had spoken to. So the entire case of the Crown consists of the complainant's evidence. And just as you say, Diana, I agree. She was totally a compelling witness. You got the feeling as she was testifying that she was recounting a trauma. No doubt about that.
So then this brings up, what's the value of cross-examination and why is it so important in our legal system?
Well, the judge did say I didn't have like a Perry Mason moment, but
Well, you said that because
I did.
that's you.
But it's the periphery, and let's just talk about one piece of evidence, and talk about the pretrial motion for a moment, because much to the surprise of the complainant,
Right.
our client's evidence, anticipated to be, and he did testify, was that in fact they were dating for about 4 to 6 weeks, and that for his birthday she gave him a tattoo book, a book about tattoos, with a very nice inscription in it, which was with a heart and her name. Not going to use her name, and said something about, hopefully you'll make better choices than some of the people in the book. I won't say more about the inscription, but it was a thoughtful inscription. He hung on to that book.
Little did she know, he still had that book 19 years later.
And that's one of those things that, thank God he did. I mean, he kept the book because to him it was special, even though the relationship to him ended poorly and he didn't really want to date her. But he kept it because he thought it was special. It was a really cool book. He thought it was a memento. He thought it was a token of her own affection. And he kept it.
It was thoughtful.
He kept it for sentimental purposes. And
it
sure
was
enough,
a nice coffee book.
That's right. But he kept it for essentially 20 years.
And she must have been pissed off.
So we had to bring a motion under Section 276 and 278 because we wanted our client to be able to testify, and we wanted to cross-examine to say that they had been dating.
Because she specifically put the nature of their relationship into question.
Correct. She said didn't know him very well.
The extent of their relationship, according to her, was he asked her on a couple of dates and she just said no. And that was the extent of their relationship. Otherwise, she only knew
there was no relationship.
She only knew him because they had mutual friends.
So we wanted to put in, to say that people are dating is not really a 276 issue, but we also wanted to say
276 being other
sexual activity,
evidence of a sexual nature.
And we wanted to say also that there was some period of intimacy before, one instance. And then there were a couple other questions that we wanted to ask, but we put in a tattoo book. And then at stage 1, everybody agreed that it was not a record, meaning this was not a document that has to go on to consideration because it doesn't invade the complainant's privacy interests.
But what happened, though, that was so interesting?
Well, you tell me.
Cross-examination.
Yeah, so
I'll tell you exactly.
So this is where there's sometimes mischief. Okay, so we spoke about how we've come to terms and I actually don't mind.
So we had to bring this motion, which made her aware that we had the tattoo book.
Right. So just set this up again. So we've come to terms in a number of episodes where we've said, this whole new regime, we're okay with it now, right?
Yeah.
We're okay. It works to our advantage. But sometimes,
if they want to cater their evidence after they've heard what we have, then we can bring it up that they're catering their evidence because they became aware of it through the motion.
But I want you to expand now how this book
interesting.
Yeah.
Okay. So the tattoo book was deemed not to be a record.
meaning
it had no expectation of privacy.
Right. So on stage 1, just so everybody understands, the complainant does not have standing. The complainant doesn't get to argue why it's not admissible. The complainant doesn't have a f***ing lawyer, okay? So they're not involved in the process in stage 1. So that piece of evidence now is off the table. However,
she still became aware of it.
Yeah, so we went to stage 2 on other issues. Obviously, the complainant's lawyer disclosed the book existence and the photocopies we had of the book and the inscription to the complainant.
Okay, so this is
Take
fun.
it from here.
This is fun. So we get to court, and the prosecutor actually asked his very last question,
which was smart by him. He wanted to blunt her cross.
Did you give him a tattoo book? And she's like, well, yes, I did. So then you start out right away with the tattoo book.
I have a vague recollection. I only had a recollection when my lawyer told me about it.
But yes, that's true. But then she turns to the judge and goes,
wait, that's
why is this relevant?
Okay, hold up. But that's on cross-examination.
That was during cross-examination.
Yeah.
So right after you started asking questions, because yes, I became aware of it.
So
what's wrong with that? She turns to the judge and says, why is this relevant? What's wrong with that?
So
The judge explained it to her.
Let me frame it for a moment. So, just so everybody understands. So the Crown smartly, because whenever you're faced with evidence that doesn't help you, address it. So when you disclose this, it means that the Crown attorney can actually use it. Right? You're not the only one who has sole possession and right to use it. So he said he asked about it. She just gave one answer. So I decided in cross-examination to start off with the book right away. Right? Go right into it. And then exactly what you said is she answered, one question. Yes, I have a vague memory of giving it to him for his birthday because I have a habit of giving books when I'm invited to things.
I just do that all the time, and I always write a personal dedication to them. That's
I always
sign it the same way.
I always sign it with a heart. Okay, when they say that, it's bullshit, right? But then after that, she turns to the judge, and you like this part so much, so I'm going to give it to you again. Go ahead, and she says,
"Why is this relevant?" She asked the judge instead of answering a question. She turns to the judge and says, "Why is this relevant?" And the judge says, "Well, I decide what's relevant."
Well, I decide, ma'am, what's relevant or not, and if counsel is not abiding by proper rules, I will interrupt. But Mr. Neuberger is asking appropriate questions, so please answer. And you could just, her whole demeanor changed. Like she went from a crying, traumatized complainant to a really annoyed, to the point where I said, am I annoying you? And the judge got a little pissed off at me.
Yeah,
but
so I remember.
Because she was giving me these faces, and she's like this, and and she storms out at one point, and actually Marcy was there, and she heard, she goes, "F***ing idiot, just get this over," which she was referring to me.
The judge didn't hear that.
No, the judge didn't hear it, but so her whole demeanor changed to this defiant, combative.
So it gets even better. After she leaves, and she's crying, and we have to take a break because she's crying, right? And then on her way, I don't
know what sparked her crying.
The
staircase. Yeah, I showed her a picture of a spiral staircase, and she broke down.
Yeah, I know. For some reason, that's the spiral.
Do you have any idea how hard it is to? Yeah, but I mean, if you got bad knees, going up a spiral staircase is really.
There's a picture of the spiral staircase she had to walk up when she allegedly was being carried in a drunken state or whatever. It was a spiral staircase. But then it was a beautiful spiral staircase. I know you don't like them, but...
I don't. I actually don't.
But
they're so
for some reason,
early 2000s.
For some reason, she starts crying when we show a picture of the spiral staircase that could have been hers. And, I don't know. That's what I assume. And so anyway, she goes out and she says, "Oh, idiot thing." And then when she comes back into court again, as soon as she takes the stand and starts being asked another question, she turns to the judge with her cell phone in her hand. You can see it lit up. And she goes, "I just want to show you something." She says to the judge, "I want to show you something." And he's like...
This is important. Please go slowly. Okay? Shh. Slow. This is a good one.
Okay, first of all...
This is one in a lifetime.
She's in a witness stand. And so you can't... When you're a witness, under cross, you can't have testimonial aids or whatever. She comes in with her cell phone lit up saying, "I want to show you something." He's like, "I don't know that this is appropriate." And she's like, "No, this is an email from my lawyer saying that he's not allowed to ask me about the tattoo book."
And the judge goes, "So, ma'am, I just want you to know, I'm the judge. I made rulings. He's allowed to ask about the book, so answer the questions, and don't refer to your phone." Right? That was pretty good, actually.
It was so bizarre, and this is the belligerence and the combative. I would say combative is combative. Combative nature of how she approached cross-examination really
undermined her credibility.
Undermined everything to do with her evidence.
And it's a perfect example of one or two things. One, I can see how, a complainant in a case where they have a legitimate argument could get pretty peeved at being asked questions. That said, I tend to be fairly polite, but insisting. But she was immediately on the back because she was caught with that book.
And the interesting part, though, is that the reason the judge definitively acquitted our client had nothing to do with these outside issues. In the end, he was acquitted because the core allegation, if you isolate it, you take out the fact that she was lying about having a relationship in advance, which I think was proved. He didn't even address that because it didn't matter. The core allegation about the way she claims she was assaulted in the middle of a very, a place where it could easily have been heard. It should have been interrupted. It didn't make any sense. And then all of the aspects of the way she said she left, I'm leaving out some details on purpose, right? But the way she said she left the place and then had to find a payphone because she had no purse. This is really funny, actually, the purse thing.
But let's just do this in some sort
Had no
of
purse.
chronological order.
Had to call collect from a payphone that didn't exist.
So you asked about the value of cross-examination, and part of the very important element here was to go from the book and then deconstruct her story, not the way you would normally when you have certain evidence that you can contradict her on, but to deconstruct a story that really draws out the implausibility and the illogical nature of it. So as you were saying, she was basically saying inferentially, because she couldn't say it directly because allegedly she's sleeping, but the notion was that our client had abducted her, literally kidnapped her from her apartment,
birthday party.
From her apartment at the tail end of her birthday party in front of other people, where she's on the 19th floor of a building, took her down the elevator, out the door, into the car, all the way to his house, where he lives with his parents, who had his mom and dad home, his brother and sister. Brother shared a shared bathroom with him, with a dog at the front door, snuck her in, carried her up the spiral staircase into the bed, and then what was also interesting was she said when she had woken up, our client was playing some heavy metal music so loud that it was absolutely
Deafeningly
deafening.
loud. She said
She couldn't hear herself scream.
Couldn't hear my own screams.
So it's not like, it's sort of low-hanging fruit, right? Like, this is not a cross-examination.
It's not really.
Well, it's not a cross-examination. You need to like f***ing have 30 years of under your belt to do this. But like, really, it was deconstructing and just emphasizing these facts, which she was sticking to nonstop.
Not a single knock on the door. Nobody, his entire family home, not a single person said, hey, turn it down.
No interruption, and she clearly saw the parents on the way out because she had an exchange with them. No issue, nothing about the dog barking. Wouldn't even give up to me that she was on the second floor of the place because I had pictures. I'm showing pictures. These are the bedrooms on the second floor. I show her the staircase. She starts to cry, needs a f***ing break. Again, spiral staircases may be very emotive to people. But like, so you just deconstruct this.
It just looks like a snail, and it's like the universe.
It was very ornate and nice, but oh, they're awful. But
I
anyways,
don't know how to explain it.
but it really emphasized sort of the absurdity of the allegation. But here's where we get to what you want to talk about, which I think is most important, is the judge's decision. So we went back to the office, worked till about 9:30, 10 p.m., did about 29 pages of submissions, sent them in. And the reason we do that is to make sure we cover all of the grounds of the evidence, all of the case law.
There's no misapprehension of evidence.
There's no mistake that anybody can make about how we're addressing facts and myths and everything. And we try and create, essentially a chess game with the judge to ensure that they are boxed in. Okay?
In terms of like understanding what the evidence was before them.
Yeah, and that they must acquit.
And also making it clear that we're not relying on myths and stereotypes about how a real victim should behave. That's so important.
And maybe the judge didn't see it as important as we did, but
because he actually just narrowed himself down to those things. But the most important thing, and I think this is a benefit to the Supreme Court's decision in the case called Kruk, which you mentioned before, KRUK, which just came out in 2024. But it's now allowed judges to use common sense. And that's what this judge focused on. He said, what I'm being asked to believe, given the other evidence that came out, because on the surface, she sounded credible and I absolutely would have believed her. But given the evidence that came to light
in
cross-examination and through our client's evidence and what he testified to, and in fact his mother testified because she had a clear memory, and I was going to mention that before, but we'll get to how funny that was.
Yeah, the purse.
The purse.
Yeah.
But he was just like, the description that was given to him in the end, given light to the other facts that came out, defied common sense and logic.
So let's say two things, and I think the judge...
He's saying it's not that it couldn't have happened, because all kinds of weird things happen. He made a good point.
There is a truism in criminal law, as he said, quite aptly, that the bizarre does happen.
Yeah. Something may seem implausible, yet it could still have happened.
100%. We've seen it. The bizarre does happen in criminal law, more often than one would imagine. But what he was really interested in were two things. One was what you say, is the implausible nature of the allegation itself, that in fact our client had abducted her from the 19th floor in her apartment in front of other people.
In front of a bunch of people.
Who would have said, what the f*** are you doing?
At her own party.
Yeah.
Where she's the center of attention. This is her
what
party.
the f*** are you doing? Like, there was just nothing about that. And then transported her
To the most unlikely place to try and commit a criminal act.
to his f***ing home, where there's no dispute that his parents were there that night.
Mm-hmm.
And at least his
Tons
sister.
of witnesses.
Right.
He was like, you would have thought if he was going to do this thing, maybe he would have done this thing. Maybe he could have done this thing, but you would have thought he'd take her someplace where he wouldn't be detected.
Right. And then the blaring music was also something hard to get around. And the judge said, two things to consider. One, if I believe the accused evidence, does the analysis not stop there? Right.
I know.
Which I thought was extremely refreshing, because he said, of course I have to assess the accused evidence and all the evidence together, but he clearly was of the opinion that her client was believable. And he felt...
He came to the conclusion that he did believe his evidence.
But so that was one thing. And then the Crown tried to rely on JJRD to say that even if you don't find
just to break
fault...
that down a moment, there's a case called JJRD saying even if you believe an accused, that you could still accept complainant's evidence if it's so compelling that it still, raises it to the point where the accused evidence doesn't create a reasonable doubt. You still believe it so compellingly. But generally that evidence has to be extremely strong, and the judge has to give detailed reasons why they weren't left in a reasonable doubt, despite believing the accused evidence was possible.
And in order to get to that type of analysis, you really have to have something external to the complainant's evidence that you can rely on. It was a diary in the JJRD case.
In that case, JJRD, they had external evidence.
So the judge in this case did not see this as that type of case, and was really taken by the evidence of our client. We had also called our client's mother, who testified in an extremely credible way about not being woken up, not hearing this music. Had we heard any music that was loud, we would have knocked on the door. That they're a very strict family.
Yeah.
And she remembered the complainant very clearly the next morning, having met her, had a discussion with her where she introduced herself to her, and she had a specific memory of her. Why?
So this is really funny because it was an element of the complainant's case that she had left in a panic with no shoes and no purse, and
running out of the house.
She admitted she happened to see the complainant's mother and just said hi, and then beelined it for the front door, and then ran to the street with no shoes and no purse. And the complainant's mother remembers meeting her, being introduced, and she was very pleasant, well put together. She was like, because at that time, kids of that age, like they'd wear jean shorts or whatever, but she had a nice dress on. She goes, and she had this cute little handbag. And he's like, you remember the handbag? The prosecutor says. And she goes, you're not going to believe it, but I actually do. It was like a hobo bag. It was really cute. Yeah. It was a hobo bag. It was like a bucket.
Well, the Crown's question was funny. So the Crown said, you actually remember it? She goes, it was so innocent the way it came out. She goes, you won't really believe it, but I do. I remember it. It was a hobo bag. And then the Crown asked, well, is that a fashion faux pas?
She's like, no, it was cute.
And I had to laugh because I thought that was really funny.
He's like, no, it was really cute. And I remember, because I'm into fashion, and I just remember that it was like, and also he hadn't dated anybody for a long time because of a breakup. And so this stood out in her mind because this is the first person, and in fact, the only person she'd ever met who slept over at the house.
So there were hallmarks, there were anchors why she would remember this. And so her evidence combined with our client's evidence really leapt to the level of believability. Yeah. So he was very much...
lucky with a 20-year-old allegation. Lucky that he had that book and that his mother
had the memory. Very lucky, because other people don't have that. But the judge was very taken back by this. This impacted the judge. So that was very important for the judge. He thought that alone would lead to an acquittal. But then he also said, and this is where I hand the judge a lot of credit and courage, because even though it's founded, I think it's grounded in case law, where you can take the plausibility of an allegation and still use that as a basis to discount the actual credibility and reliability of the complainant. One might argue that you should not do that, but this judge said the actual framework or the facts of the allegation as described by the complainant tested the bounds of logic and reason. Good for him.
Welcome back, Logic and Reason. I'm so happy.
Good for him. Good for him. Not done yet, but we can clink. So,
Click to that one.
So I have to say, and this reminded me a little bit of Justice Malloy, one of our favorite judges to run trials in front of, because you just can't get bullshit by her. She's got a bullshit meter like nobody. Okay,
yeah.
And she engages in submissions, and she can call it right away. And His Honor in this case engaged in submissions, which was great. It's very good when they talk and ask questions and try and hone in. And his bullshit meter was up, and he said, I just can't. Like, there is a truism that the bizarre happens in criminal law, but really, and then this line will stay with me forever. It tested the bounds of logic and reason. Mm-hmm. And that is such an important finding.
Yeah.
Because a judge was able to rely on, he also said common sense. It tests common sense. But
every time a judge says common sense, I'm just like, ding.
Yeah, because for a long time,
awesome.
if you said that, you were in deep shit because you're engaged in myth-based reasoning.
If the defense said common sense, the judge would almost cringe.
Because they're terrified of it.
I know.
Because we cannot engage in discriminatory analysis or reasoning against the complainant. Absolutely true. But there's nothing wrong with saying this doesn't fucking make sense, right? And blaring heavy metal music at 2, 3 o'clock in the morning. That's
so
deafening in nature.
Hear her own
deafening,
screams.
so loud that I can't. Deafening in nature in a house where his parents are clearly living there, sleeping at
the
that
end of the
night.
hall.
It's 10 feet away. The room
Yeah.
defies common sense and logic.
Yeah. So
Along with the abduction, and then I think in the back of the judge's mind, because I did cross-examine. It's a little touchy on this. I said, "So where are your witnesses?"
Right,
and she goes, well, I said, did you give the police officer contact information and names of your potential witnesses? I did. There were statements taken. And I remember the Crown saying when there was a break to the cop, did you take any f***ing statements? No, I didn't take any f***ing statements. There was nobody who backed this story up. The reason I wanted to lay that down was I wanted the judge in the back of the head to think, well, there doesn't have to be corroboration, but where the f*** are all these people she spoke to?
That said, Joe, the judge said that it defied common sense, but it didn't defy common sense until you cross-examined.
Okay, we'll end on that one. That's a good one. Thank you. So, common sense, logic, and reason
Tells
are
you
back in fashion.
To like our channel, comment, subscribe, and share.
It's not just a
Remember,
fashion.
hit notifications.
It's not just a new fashion trend for the fall of 2024. I think it's here to stay.
BJ's going to like that one, right? I did that well.
Very well. He doesn't like comment, does he?
No, but we like comments because we get great comments. So thank you very much. So
BJ
like,
doesn't
share,
like comments?
subscribe. Thank you very much. We get great questions, and this was a good case, eh?
It was fantastic, and I'm so happy for the family.
Yeah, they're totally relieved. So
And they can finally move on.
yeah. Good night, everybody. Thank you.